Order, and welcome to this afternoon's session of the Justice Select Committee, which is the final evidence session on the large inquiry we're doing into access to justice, and therefore we're very pleased to have the Minister of State, Sarah Sackman KC, to give evidence before us, accompanied by some of her senior civil servants, who will be introduced in a moment. But first, members of the committee will make their declarations of interest, starting with Sir Ashley Fox.
Ashley Fox, I'm the Member of Parliament for Bridgewater. I'm a former solicitor and my interests are on the register.
Neil Shastry-Hurst, I'm the Member of Parliament for Solihull West and Shirley. I'm a barrister with a current practising certificate and my interests are as declared on the register.
I'm Andy Slaughter, I'm the Chair of the Committee. I'm the Member of Parliament for Hammersmith and Chiswick. I'm a non-practising barrister. I'm a member of the GMB and Unite Trade Unions, and I'm the patron of two justice-related charities, the Upper Room for Ex-Offenders and Hammersmith and Fulham Law Centre.
I'm Vicky Slade, MP for Mid Dorset and North Pool. My interests are as per the register, but none relevant to this committee.
My name is Tessa Mont. I'm the Member of Parliament for Wells and Mendip Hills in Somerset. I'm a Vice Chair of the Penal Affairs All-Party Parliamentary Group, and I'm also a Director of Whistleblowers UK, of which that's a non-profit making organisation.
Hello, my name is Sarah Russell. I'm a Member of Parliament for Congleton. I am a solicitor with a current practising certificate. I did employment law for 13 or 14 years before I came here. I am Chair of the All-Party Parliamentary Group on Access to Justice, and I am a member of various other APPGs and trade unions.
Good afternoon, Pam Cox. I am the Chair of the All-Party Group for Penal Affairs, and my other interests are as declared.
Hello, good afternoon. I'm Warren DeJust, Member of Parliament for Wolverhampton West. I'm a solicitor but not practising at the moment. I'm a member of the GMB Trade Union Central Executive Council and a member of various APPGs.
Hello, I'm Tony Vaughan, the MP for Folkestone and Hythe. I am a barrister with a practising certificate. I was formerly an independent funding adjudicator for the Legal Aid Agency and otherwise draw attention to my register of interests.
Thank you very much. And Ms Sackman, would you like to introduce yourself and your colleagues?
Thank you, Chair, and good afternoon. To my right, I've got Ms Jane Harbottle, who's the Chief Executive of the Legal Aid Agency, and to my left, Farah Ziaulla, who is the Director in relation to legal aid and legal support at the MOJ.
Thank you very much. If I just begin with a few general questions. We received over 2,000 written evidence submissions for this inquiry, and they painted a pretty dramatically bad picture of the state of access to justice, which I'm sure we all here agree is a fundamental principle of the rule of law and indeed a functioning civil society. I mean, do you agree with that bleak picture, and where do you think the most acute problems are?
Access to justice is the right which makes all other rights real. And you're right to say that that constitutional right to access the courts is fundamental in a democratic society. I also believe that it's fundamental to social and economic justice as well. And when one considers that it was almost 80 years ago when, out of the ashes of war, the Attlee government created the legal aid system as a pillar of the welfare state, I think that today in government we should be no less ambitious in our attempts to revive it. But you are right, the inheritance that we received as a government was dire. I think it's fair to say that over consecutive governments, the approach to legal aid has been one of managed decline, and whether in terms of the workforce, the provision, the systems on which our legal aid and legal support systems sit, be they digital or in terms of people, we inherited a system that was in dire need of investment. Morale was low, eligibility and scope had been slashed, and I think that the inquiry that the committee is undertaking is well timed, because I've seen in my time in this role my primary goal to be one of stabilisation, because unless we can fix the foundations of our legal aid system and fix the foundations of access to justice in this country, then the bold approach that I believe is possible and is necessary will not be possible. And what we have sought to do in the first coming up to 2 years in government is to stabilise the system in terms of making the necessary investment both in criminal legal aid and in civil legal aid targeted at those areas which have been identified precisely because they are the areas of most acute need. The duty solicitor scheme in crime, prison law, immigration, housing, all of that is vital investment, which we can go into in more detail, in order to stabilise the system, and major investment too in the IT systems, the digital systems on which legal aid is dispatched. And looking ahead to the future, I think with that stabilisation, we are beginning to see some green shoots, both in terms of the numbers of providers entering the market, the retention of legal aid providers in the market. And I hope that by fixing the foundations, we can then turn our ambitions to building the bold vision of access to justice to which this government and I aspire, one which harnesses the potential of technology to lower barriers to accessing justice, one which develops the new pipeline of legal aid practitioners through the investment that we're making in legal aid in publicly funded pupilages. And ultimately, all of that is about empowering people, because I'll end this opening answer where I started. Access to justice makes rights real. The rights that we extend to people aren't worth a jot if they can't be enforced, if they can't be enforced in a court of law. And that isn't just about what happens in court, it's about what happens in the shadow of the law as people go about their lives knowing that the justice system is there for those who need it. So if we're to vindicate the promise that the Attlee government made to the British people back in 1949, I believe we can be just as ambitious in reviving the fortunes of legal aid in 2029.
You covered a lot of bases there. One of the issues you mentioned was eligibility. If I can ask you a couple of questions about that. The gross income eligibility threshold in the Magistrates' Court is currently £22,325, which means a single person working full-time at the minimum wage earns too much to be eligible. How can that be justified?
The choices that were made by previous governments in LASPO in relation to eligibility have, without doubt, had the effect of residualising access to legal aid. Legal aid was always, in its conception, designed to ensure that those without the ability to pay to access the court could do so. Now, I well appreciate that when the scheme was conceived, that it captured a far greater proportion of the population than it does now, because, as you say, the eligibility thresholds mean that it is a resource, a finite resource, that is targeted at the poorest in society. What I would say is that building on the evidence base in the Rockler report, which looked at the means test and looked at the question of taking into account not just income but other costs of living, the government will be setting out our plans in due course with regard to revisiting the whole question of eligibility.
I know the classic phrase "in due course" there. I mean, one of the consequences of that is that of that low threshold high threshold. It's 48%, for the latest dates we've got, which is about 3 years ago, 48% of defendants appearing in magistrates' courts for imprisonable summary offences were unrepresented. So you've got nearly half of defendants facing possible prison sentences with no legal representation. That can't be right, can it?
Well, as things stand, 31% of those who appear in the magistrates' court are publicly funded, and 97% of those who apply for legal aid receive it. People may be litigants in person for a whole host of reasons. Some of that may be to do with choice. It may be because they have substantial means and simply choose
48%.
not to. But I don't deny the force of what is being put to me. That has been the case for some time now. What I would say, and I alluded to this in opening, coming into government, we had faced some pretty stark choices. The fact that civil practitioners in housing and immigration had not received a pay increase since 1996. We put that right with a £20 million worth of investment. We could also see that those that you're talking about, so even the residual number that are represented in our criminal court, you had duty solicitor schemes that were literally collapsing. Again, we put that right by investing £160 million in criminal legal aid fees for solicitors in steady state. That is a substantial new investment, because whilst you're right to push me in relation to eligibility, do I think that coverage is generous enough as things stand? No, I don't. But there are choices to be made about ensuring that even the 31% who are eligible under the current thresholds, that their needs are actually met. And in a system where we see an attrition amongst duty solicitors, amongst criminal legal aid practitioners who hadn't seen a pay rise in a very long time, I believe that was the right choice to make within the first 2 years of this government.
Two of my colleagues which come in, Sarah Russell and then Neil Shastri-Hurst.
Minister Sackman, you have referred to the fact that 48% of people are unrepresented in the magistrates' court. In the Crown Court, where people are being accused of exceptionally serious offences, the total household income to entitle eligibility is £37,000. That could potentially be two people's earnings, not just one. So there will be significant numbers of people who are completely unrepresented in the Crown Court. Firstly, when you say that we've put things right in the legal aid system and that we are being ambitious around the Attlee government's vision, do you consider that that meets that test? And secondly, what assessment has the government made of how much longer trials are or aren't taking where people are unrepresented litigants in person, and what the potential cost of that is within the system?
What I was trying to say is that that's the aspiration. My aspiration is a bold one, which revives this system because I believe in it. And I reject the approach of managed decline of predecessors in my position. But I cannot get to that bold vision unless I'm serious about stabilisation. You're right to highlight litigants in person in the criminal court. And one of the things that we are looking at afresh as a department is the support that we provide to litigants in person, be they in the magistrates' court or indeed in the Crown. There is provision in place in the form of a hardship mechanism where the costs, whilst they may not be eligible, where the costs that are borne are deemed of a level that funds should be provided. There is the duty solicitor scheme. The system, of course, whether through judges or the legal advisor role in the magistrates' court, is used to dealing with litigants in person. That's part of the equal treatment handbook, and that access to the court shouldn't depend on whether one has representation of the most expensive kind, of the cheapest kind, or none at all. You should still be able to access the court. But I do take the point. I am not comfortable with the numbers of litigants in person. I know from my own practice, which was a civil practice, I grant you not a criminal one, that some of the processes in our courts can be difficult to navigate for litigants in person, where there are legal issues rather than factual ones, then staying focused on the relevant issues can be more challenging where there isn't legal representation. So please don't misunderstand me. I'm not comfortable with the situation, but politics is the business of choices. To govern is to choose, and we've made some pretty bold choices early on in this government. We've got to make sure that those bed in and work. Implementation takes time. But litigants in person and the way we approach and support litigants in person is something that, as I said, as a department, we are looking to build on the existing support that is provided.
Minister, could I press you on the second half of that question, which is what assessment has the department made of what the impact is on trial time of unrepresented litigants in person and how much that is costing within the system?
So I know this is something that we've sought to look at. It's one of those things that is actually quite tricky and complex to collect data on, but I think that Ms. Ziaulla might want to comment on some of the detail.
Yes, absolutely. So as you say, we recognise that this is something that we need to have a much better understanding of holistically and in a systemic level. We hear a lot anecdotally, and as the Minister has referred to, there are various interventions in place to support litigants in person. But one of the PAC's recommendations was that MOJ and HMCTS work together on a scoping study to look at precisely the impact of litigants in person in terms of the costs and efficiencies of trials and cases progressing through the system. So that is something that we are working with HMCTS on, and we are looking forward to having a much more robust sense of the data, and then we can determine what the most appropriate action or suite of options might be to take forward.
Thank you. I need to know, Neil.
Thank you very much. Currently, there's no official regularly published statistics in terms of those defendants who are unrepresented at magistrates' hearings. Are there any plans to publish that data?
I think you heard the answer that Ms. Ziaulla just gave about trying to get a handle on the data and the impact that it's having. I think there are no current plans to publish that data, but no doubt that is something that we want to look at. We're not going to, as a department, I would say, generally speaking, we collect a hell of a lot of data, an awful lot of data, I should say, and we look to publish it and to be as transparent as possible. So no doubt, as part of that exercise, the total numbers that we're seeing in different jurisdictions is something that we could look to collect and then publish. There are no current plans, but I think the point raised is a good one.
It has previously been published. It was published in response to a parliamentary question. And so it's clear that that data can be found if it's wanted to be found. The Lamy Review back in 2017 recommended that data should be published on a regular basis, and the Office for Statistics Regulation has said it's a crucial measure of access to justice. Given that the Lord Chancellor believes it should be published, why is there no active plan to deliver that by this government?
Well, I think that you make a good point. And it's one that we can take away from this committee and look at the desirability. I suppose the only thing is, as with all data, it's important that firstly, the data is robust and paints a complete picture. And secondly, that it's set in its proper context, because I think, as I said earlier, whilst I don't deny that one of the reasons, maybe even the primary reason why people choose to represent or don't find themselves representing themselves is due to the eligibility around legal aid. There may be other drivers of that too, and I think you would want to understand that as well. So you make a good point, and it's one that we can take away, but it's one that I would want to consider holistically in terms of what data we have, how we're gathering it, and ensure that it's presented in its proper context.
And just sticking with eligibility for a moment, the last Conservative government announced in 2023 plans to increase the income thresholds by £3,000 for civil claims, by £12,000 for criminal cases. You've now been in government for the best part of 2 years. How come that hasn't been implemented yet?
Well, you're right that I should say, the previous government implemented the first phase of its means test review after 14 years in government. We have taken a different approach that I began to set out in relation to stabilisation, and we prioritised the fees side of things, and I think that was the right thing to do, because if we don't have the legal aid providers to service even those who are eligible under the existing thresholds, then there's no point in extending eligibility if you haven't got those to actually carry out the work. So that's the choice that we've made in the last just under 2 years or so. And as I indicated to the Chair, we will be setting out our plans in response to the means test review exercise that was conducted.
Can you say roughly when?
I can say that it'll be this summer that we'll set out our approach. I think it's important to say that the evidence base gathered under the previous government has informed some of our decision making. So the choice that I referred to earlier to make investments in civil legal aid in relation to housing and to immigration, which has been well received by those parts of the sector, was informed by that evidence base. So it's an evidence base that we use, but I think the choices that we've made in relation to increasing fees and making investment in particularly our digital systems which support all these fee changes, I think those choices are fully justified.
Just so I can keep an eye out, when you say summer, is that before the House rises for summer, or at some point over between now and September? I'm
not going to commit to it being before the House rises. Summer is the summer, and we will publish it, as I said, in this summer phase before the autumn.
By the 21st of September, I think that's yes. I do need to move on, but Marinda and then Tessa.
Yes, just very quickly, is it your aim across all legal areas, that includes criminal and civil cases, to have as few litigants in person as possible? Because in my experience, there are delays with court procedures with litigants in person.
You refer to all jurisdictions. And I think the premise of that question, of your question, I think presupposes that a litigant in person is always a sign of, is always a negative, if you like, because most people would choose to be represented in that context. I would say that, of course, the reason why we are committed to a legal aid system which has always been targeted at the poorest in society. That's the way it's been designed, and that's certainly the way it's been administered for the last few decades, so that the question of access to justice doesn't depend on people's wealth or ability to pay. But I would say this, there are contexts in which the ability for people to access the court without the need necessarily to be represented or have it mediated through lawyers might not necessarily be an undesirable thing. That was, and I can see that some have their heads in their hands, but I say it in this way. When tribunals were set up, and the reality for many in family courts is that the court should be accessible to any person, irrespective of whether they have legal representation. Now, of course, as someone who's practiced law, of course, I understand and believe in, and that's why we're investing in the professions and in the pipeline into those professions, because of how difficult these processes can be to navigate. But why I don't take that as the only metric is that we need, for all these processes, to not be alienating to the individual, to not set up barriers, to strip it back and explain it to people. We've got to do that within the Ministry of Justice as well, in terms of how we explain, simplify processes, so that we don't set up barriers to access to justice that are not just about money and about representation, but also about people understanding what's going on in court. So I do understand the force of your question, and of course I don't want to see huge increases in the numbers of listing a person. Of course it's a negative metric in most senses, but I think we also have a job of work to do to make sure that our courts and tribunals are accessible to ordinary citizens of this country in a way that doesn't always require it to be mediated through the professional language of legal professionals.
And finally on this, Tessa.
Yes, just very quickly here. Warinda's asked part of my question. Have you considered actually asking, surveying every court user whether they would want to have had legal advice? It's a simple tick, isn't it? Because then you'll know. Your contention is that some people, many of those people perhaps, would want to do this themselves. My suspicion would be that's not the case. I think a lot of people want help. I just wondered how much surveying you've done and whether you consider doing that, so you actually have facts as opposed to supposition.
Well, we'll take this, it's worth taking it in stages. There's the question of unmet demand in the context of who is eligible for legal aid under our current system, or even who might be eligible under a reviewed means test. Then there is the question of access to justice more generally. Legal aid has never been universal, however desirable I might think that is. And the reality is, and I say this with clear awareness in my role, that very often access to justice is there for the very wealthiest in our society and the very poorest. And there isn't a whole lot of access to justice for those in between who might need or wish, indeed, to litigate. That, I think, brings us to the importance of something like legal support. So the committee will be aware that the government has committed to £20 million worth of multi-year funding for legal support, which often takes the form of law centres. And they do brilliant work in terms of providing people with free legal advice, and particularly early intervention, which can head off a lot of legal problems at the pass. So, as I said, there's the question of unmet demand within the current system, and we're currently undertaking a study into that, and I might bring Ms. Ziaulla in that in a moment. And then there's the wider question that you asked, Ms. Munt, which is around everybody else who might wish to access the law and the courts. That's tricky in a way. In some ways it's a bit unknowable, because you've got your proposition, which is, well, let's survey everybody who comes to court and who would have wanted more legal support, and that would be one metric. But there may be a whole much larger number of people who never even come to the door of the court because they never litigate or defend a claim or whatever, because it's not available to them. And I'm realistic about that. It's why I'm such a strong believer in legal support, and why I'm glad that we've made that multi-year investment, because that is incredibly important to bridge the gap between the wealthiest in society and the poorest, who at the moment are very often the only people who can access justice properly.
Thank you. I do need to move on. We've got some questions now from Tony Vaughan.
Thank you, Chair. Thank you for your answers, Minister, and thank you for the steps that you've taken, that you've described, to stabilise the system, particularly in areas that haven't seen a pay rise for a long time. I'm going to ask about legal aid deserts. In January, the Public Accounts Committee reported that there are around 19 areas where housing and debt provision were in real short supply. And last week, I think you issued an invitation to housing and debt providers in 45 areas to maintain strong coverage. So does this indicate that the gaps in provision are getting worse, and what is the department doing about it to address that?
The starting point has to be that it should not matter where in the country you live or what background you come from. You should be able to access legal support and, provided you're eligible, legal aid. We've got to end the postcode lottery. I think that it's important to refer, and I may bring Ms Harbottle in here in a moment, to the procurement of legal aid and indeed the coverage of legal support. We look to ensure that we have duty schemes covered across the country, that we aim for one provider per category of legal aid per procurement area, except in family, where the target is to have 5 in a procurement area, and with the exception of 9 out of the 107 areas in family where we do have a shortfall, that coverage is there. I think it's also really important to refer to 2 things which are changing. One is within the legal aid agency itself, which no doubt Ms Harbottle will refer to, which is the flexibility in contracting and procurement that the LAA has adopted more recently. That is to take an always-on approach, allowing providers to enter into the market at different points in the procurement cycle, removing requirements around having physical offices, and that's going to bring me to my second point, which is around remote access. In today's day and age, and of course being alive to the realities of digital exclusion and those areas of law and vulnerability where face-to-face is needed, where the majority of people carry around with them a smartphone, the ability to access justice should be easier. And indeed, the choice, we should be affording choice irrespective of income, right, to people. Choice when it comes to provider and specialist should be far greater because, as I was increasingly doing before I came to this place, undertaking conferences and consultations with people through remote video mechanisms is a huge boon to access to justice. So I suppose what I'm saying is the principle is one of no postcode lottery. The procurement is, we think, healthy to provide coverage such that some of the language around deserts I don't think is hugely helpful, and the flexible approach that the LAA have taken is a good one. And finally, I think that harnessing the potential of technology can really help us alleviate deserts where they do arise.
Just in relation to the actual nature of what is called a desert, I mean, do you accept the Public Accounts Committee's position that there are 19 areas of the country where really there are real problems in accessing those areas, or how would you characterise the nature of the deficit in the availability of legal advice in any particular areas of the country?
It may be worth me bringing in Ms Harbottle here, and then perhaps I can add to that.
So I'm more than happy to come in. I mean, I do recognise that because I think I actually told the Public Accounts Committee that position at the time, or probably over a year ago. I think the Minister is right in terms of the way people are accessing services is changing throughout the legal market, even in the legal aid market. People are utilising more remote services. And we have adjusted our contracts accordingly, and we're currently discussing with the contract bodies, the Law Society, LAPG, Advice Services Alliance, about the huge expense and cost that providers have in terms of office overheads, which is one of the absolutes in our contract. We're very specific about what time it has to be open, etc., etc. But I am not dismissing concerns. There are, of course, still concerns across areas of the country where we do struggle to meet our own standard. And what you saw last week was us changing our approach now that we have our contracts always on, now that providers can come in at any time, now that we only take 3 months to turn those applications around rather than a year. So we currently have, in housing and debt, because your question, Mr. Vaughan, was specifically about housing and debt, we have 21 areas where there is no face-to-face provision, so there is no one housed in a particular office. Now that we are not doing these huge monolithic tenders, I have some staff available who can really drill down into these areas and work with providers locally to see what we can do. So 9 of those areas are currently covered by outreach services, so providers from other areas areas of the country. And
so
we're
forgive me,
working...
in practical terms, does that involve setting up some sort of remote advisor that goes into the office of some other organisation that you commission?
Be a mix. So we will work with the providers on something that works for the people who are willing to provide the service and the particular premises, etc. So it could be outreach in a particular location, physical, or more likely it's probably remote, or it could be a blend of the two.
From the perspective of the public, how would they know about that, or how would they go about accessing that?
Well, all of the providers in those particular areas are told about the accessibility and know that they can clients can access services those ways. We also have, of course, our civil legal advice telephone service, which is advertised in court material, court literature, and through advice services locally, etc., and has been for many, many years. And that is still used and still available in all areas of the country, or all areas of England and Wales, for housing and debt matters. There are a further 12 areas where we don't have outreach arrangements. They are reliant either on the phone service or if they can get advice remotely elsewhere, or also through our Help Us service, which is a new service that provides on-the-day advice in court, but it also provides, in the lead up to that, advice in welfare benefits and debt. And we have full coverage in all of those contracts at this moment in time. We've personally intervened and made sure in a couple of those just to make sure that we've managed to secure services in those areas.
Thank you. Just turning to the Minister again, I just want to ask about how we monitor demand. So we spoke a moment ago about how it can be difficult to work out how many people never ended up asking for advice in the first place or couldn't be represented. I mean, your research from the Civil Legal Aid Review shows that we've got this issue of rising demand and people being turned away. What is being done to better monitor demand in perhaps by imposing a duty on providers perhaps to record whether they have to turn people away, for example? Because I think you accepted that is fundamental to understanding the real deficit here.
So just picking up on the previous question really quickly, if I may, and then coming to this point about unmet demand. I think what you heard Ms. Harbottle's answer is that, there is there's a good awareness of where there are gaps, and that the LAA, certainly from what I've seen, is proactive about seeking to plug those where they arise. And I know, for example, there have been issues around family law provision in Trafford, and getting in on the ground and seeking new providers and making sure that they're sustainable is an approach that I've seen, and I've seen it working well. The aspiration, I should say, is, and this is talking about the bigger, bold ambition, and I hope I don't say this in a starry-eyed way, will be, under our transformed systems, to getting to a single front door, whereby eventually the end user, the citizen, can apply direct to the legal aid agency and then be pointed in the direction of a suitable provider, be they very local to them or perhaps a bit further away. And I think would be a really desirable position for us to get to. In terms of the point about unmet demand, I think the first thing to say, and I really want to sort of thank this committee over a number of years for highlighting this point, because I think there is always a danger that an absence of evidence is treated as evidence of absence, and of course that can't be right. And so what we are doing is undertaking more research in order to understand what the position is in relation to this. So the demand feasibility study, to which I think you were referring, obviously published just the other day on the 5th of June, is a really helpful document, because it steers us as to how we can routinely go about monitoring demand, including unmet demand, for civil legal aid by eligible individuals, which is really difficult to do. That's what it says, so it's really complicated, but it does suggest a way forward. We've got a pilot which is looking to monitor demand. It builds on that feasibility work. That's in That's in train. We conduct regular provider surveys. That's a really useful source of data. So we've got a survey that just closed on the 8th of June, which will help us paint a pretty comprehensive picture, certainly of provider capacity, but also demand. You know, where are they turning away work that will represent unmet demand potentially?
Will it deal with this suggestion that they will take on work where you can make ends meet and reject work where they can't? I think some people have called it cherry picking.
Well, I guess I'm making a more general point. I mean, you know, there's the reality of capacity. You may just have to turn away work because there just isn't capacity. Insofar as there are examples of where people are choosing more lucrative areas or certain areas which interest a firm more, and you know, ultimately those are. There's a degree, even within publicly funded work, of commercial choices that firms will make, provided, of course, it adheres to, well, certainly the barrister profession, to cab rank laws and what have you. But that still represents, if not a failure of the market, then a serious problem. So to the point of getting a grip on this problem and understanding it, that survey provides us with rich information about what work firms are and aren't able to take on or aren't choosing to take on.
And so how far do you think we are away from having the information that you need to really get the actions in place to address this issue? Because we've got, I think the Lord Chancellor said when he was before us in December that you've got this new survey, you were talking about providers, you've given some more detail about that. I mean, given all of this, I mean, are we close to the point where you think you've got enough information to actually go and attack the problem? Or do you think a lot more is needed before we can say that we can...
So I'm going to answer that in two ways. The first is that I think we do need more information. So the report published on the 5th of June tells us that the way we need to approach this takes a bit of sophistication if we're to get a real handle on it. And so it's not job done. So there is more work to do. But the second part of my answer is not to sit on my hands and say, well, because we don't know, therefore I'm going to assume that everything's hunky-dory. Of course not. That's why I'm making the investments that I'm making. That's why we are flexing the approach to procurement. That's why we're doing some whizzy things, flexible and dynamic things around paying people's travel expenses so that they can get a further reach in terms of their provision. It's why we're doing all of those things, as well as the long-term work of not just stabilising, but growing the provider base. So whether that's match funding for 100 new publicly funded criminal pupilages at the bar to start coming on stream in 2027, whether it's some of the trainee schemes that were funded by the Legal Aid Agency. I was literally talking to somebody at Derbyshire Law Centre yesterday who was saying how they've benefited from that and have now got 2 new housing and welfare lawyers in their law centre because of funding that was provided by the Legal Aid Agency. That's not sitting on our hands whilst we wait for this information, but we do need to make sure that data is not just data, but it's actually robust. So we're targeting the right thing.
Thank you, Minister.
Thank you very much. Windjust.
Yes, Minister Sackman, in your introduction you mentioned the duty solicitor scheme. However, between October 2023 and 2025, the number of active duty solicitors decreased by nearly 30%. And we know that criminal law is not deemed to be an attractive area of the law to go into for our young lawyers. There have been cases where duty solicitors are working for 20-hour shifts and then getting up and doing the rest of their work, and even cases of duty solicitors not being available to the extent that the police has then had to release the suspect because the interview can't go ahead without legal representation. So what modelling or workforce planning has the government done to make sure that we have got a sufficient number of duty solicitors available?
It's a really important point, and it's one that I was seized of coming into this job, not just the attrition and numbers that we're losing from the duty solicitor scheme, but also some data that the Ministry of Justice holds in relation to the age of those solicitors. So not just the problem we have now, but the problem we're going to face in 10, 15 years' time as people come up to retirement. And it's why when we increased solicitors' fees, that increased investment of £116 million annually in steady state, that when we were making choices about where to target that money, I recognised that it was important that we really focus on the duty solicitors, as well as prison lawyers, which is another area where, partly because of the nature of the work, going into prisons, going into police cells, often at pretty ungodly hours, makes that kind of work difficult. It's certainly not a case of saying, well, job done, but that is an important part of the stabilisation, and to show that that investment is a sustained investment, to make people who are making choices early on in their careers whether to stick at this area of law rather than perhaps switch to another, that funding and those fee uplifts are there so that they can have some economic security about it. We also committed money within that, and I'm sure Ms Ziaulla will correct me if I don't get this exactly right, around some of the travel expenses for duty solicitors, so that if it were outside of their particular area, they could get there and have those expenses paid, so not to dissuade people from doing that kind of work. So you're asking a really important question, and it was one that immediately jumped out at me when asked to make choices about what we should prioritise. It was clear that if you can't get your duty solicitor there down at the police station to inform you of what your rights are and help you navigate what can be a very, very important first phase of a criminal investigation or whatever, then that is very serious indeed. So I hope that the investment we've made will achieve that stabilisation, and then we'll have to build on that.
And this may be a question for you, Ms Ziaulla or Ms Harbottle. Has the legal aid agency done any investigation to find out whether the increase in criminal legal aid fees is obviously very welcome, and it is something that lawyers had been chasing for. So has there been any kind of investigation done to suggest that it is having an appreciable effect in attracting more criminal defence lawyers into the profession?
Shall I come in if that's okay? So it's very early days, obviously. We did let and award a new contract at the 1st of October 2025. And at the time, we attracted 1,021 providers. Now, of course, because providers can come in at any time, bearing in mind this is completely new, this would not have happened before. We've had, and these are, I must stress, these are unofficial statistics to the end of April. We now have 1,045. So some green shoots because we have seen a 2% increase. So we are getting about, on average, about 4 new applications a month. What we're not seeing yet, and it's a bit too early to tell, is whether that translates through to more duty solicitors, or whether it's just sort of further consolidation or sort of fragmentation of the market. The other thing I must stress is, of course, we also keep a register of accredited representatives, and there's 2,148 representatives who help at the police station and serve police stations across England and Wales. This is an area where we need to really improve our data, because of issues in the past with the way we collated the data, with the way it's reported to us. We can't see any sort of trends, whether that's going up or down. So that's something my team have done a complete cleanse of. So going forward, we can see what the trend is for accredited police station representatives as well, who will support, of course, the duty solicitors at the police station.
Could I just come in on that as well? I think in addition to what Ms Harbottle has said, I think it's also important to note that all the schemes have remained covered. That is as a result of the investment that is being made and the monitoring as Ms Harbottle refers to. And just looping back very briefly to the earlier question about the research that the department is undertaking. We have the feasibility study on demand. We also have the provider survey, which has just closed yesterday, and that went to all providers, the whole provider base right across crime and civil. We also intend to do a profitability survey as well, which will look at what makes this work profitable, balancing both the fee levels but the administrative burdens, the overheads, what incentivises practitioners to do the work, and what actually starts to feel prohibitive. So there is a whole range of data that we are looking at, and back to your question, absolutely, we want to be able to act on it, but we want to do that in an informed way when we've got a holistic picture, and we are confident with taking that kind of multi-pronged approach that we will have a lot of data to draw on, and that we are much further forward than in previous inquiries and sort of our recommendations from the NAO and PAC, that this is something that we need to do, and that is informing all of the investment, be that financial or otherwise, that we are making into the system.
Thank you. So questions from Pam Cox.
Thank you. Turning now to civil and then to family legal aid, if I may. Minister, in December, the Lord Chancellor told us at Justice Questions that the MOJ would, quote, look across the piece at civil legal aid. How is the MOJ planning to take action on civil legal aid schemes?
Well, the first thing we've done is to make the investment in housing and immigration. That was really important to do. It was important both in terms of the scale of the investment, £20 million, but also in terms of implementing those fees. That sounds simple, should be simple. It's not simple because, as you'll recall, we had a major criminal cyber attack on what were, on any view, totally a system that was totally unfit for purpose. So getting that to those civil providers was incredibly important. The other area, which I've not yet mentioned, of course, is the biggest extension of legal aid, which, albeit not yet enforced, but to which the government is wholeheartedly committed within the scope of the Hillsborough Bill. And that is to support bereaved families at inquests where public authorities are interested persons. That's a huge extension of legal aid, and when it comes into being will be really important, I think, not just in relation to vindicating the tireless campaigning of those who fought for the Hillsborough Bill, but I think representing something really fundamental about the balance of power in this country and who gets to be represented in those sorts of settings that won't be means tested. Those are some really important early choices that we have made. I've made reference earlier in response to Dr. Shastri-Hurst's question that we will be setting out our approach to the means test, and that will have relevance to our approach to civil, more generally, civil legal aid, because it's true to say that civil legal aid probably fared the worst when it came both to LASPO and, I'm afraid, also the cyber attack, because we managed to reinstate our criminal legal aid systems quicker than we managed to reinstate our civil. But I hope that we have given, as a government, a very clear indication of our commitment to the future of civil legal aid by the investments that we've made early in this government.
Thank you. And if I could turn to Jane Harbottle on a similar matter. Last December, you implemented legal help fee increases for immigration and asylum and housing. You cited at the time issues with IT systems as to why this was not more generally extended to civil representation. Are those issues now resolved, and when will that uplift be implemented?
In terms of the sort of timing of the uplift, obviously that's a sort of matter I'll pass to Farah to cover, but in terms of the impact of the cyber attack, we have restored most of our systems, or virtually all of our systems, externally, or replace them. However, we still carry a significant amount of contingency and forward work internally across the agency. So crucial work like our ability to gather data, management information, to be able to lay our accounts. We're also focusing on laying data foundations and improving our security posture going forward so that we can do the transformation work that Minister Sackman has set out. So we will implement them as soon as possible. Farah, you may want to come in here with the policy position on that.
Yes, no, I mean simply to add, as you say, that we have been, it's been fantastic that we have been able to implement 18 million of that uplift. So a significant majority of it, but doesn't take away from the fact that there is 2 million for representation, as you say, which providers, and we are very keen to get into the system. It would be remiss of me to commit to a date now, given the challenges that we are sort of navigating as the aftermath of the cyber attack, and wanting to make sure the system is robust to deal with implementation. But it is something that we're really focused on, and we will look to do that as soon as possible.
Thank you. And when you are able to implement the uplift, will you commit to ensuring that it's backdated to December 2025 to ensure continued viability for providers?
So the position on uplifts is that they are forward-looking and not retrospective, and that's the position that we expect to maintain.
There's no room for negotiation on that?
No, and there's a practical point there, which is we're sort of dancing a little bit around this issue, around the underlying system. Every time government, and this would be true, government that's of all shades, every time government announces a fee change or uplift, it's incredibly difficult to implement. And there's a very simple reason for that. That's because of years of people who sat in my position ducking the big decisions around investment in what are absolutely atrocious legacy systems. By the end of this Parliament, we will have achieved, we may not have done the whole project, but we will be on reformed systems which are not just safe and secure, so we can hold people's data in a lawful manner, but so that we can do the very basics that are provider-based in legal aid and that the citizens should expect. Because it's the fact that you speak to practitioners, as I'm sure you do in this committee, and they will tell you the countless hours. Often they tell me 30-40% of their time is spent wrestling with our dreadful systems. I don't want to keep announcing fee uplifts if we can't actually implement them. It's incredibly difficult to backdate and do it retrospectively. So there's a practical as well as a principal barrier to it.
Thank you. And now to turn to family legal aid. You'll know that it's so important, Minister, in tackling violence against women and girls that family members have solid access to justice. Will the forthcoming family justice strategy be accompanied by uplifts to family legal aid rates? And this is of particular interest to this committee because we're taking a lead on organising a multi-select committee event on the family justice strategy very soon.
That's really great to hear, and I'm sure that Baroness Levitt, who is leads on family justice policy, will want to participate in that, and I'd love to come if the invite is extended.
Absolutely.
So there's no denying not only the challenging environment in family legal aid, but also the critical role that I believe, and I agree with you, that it plays in tackling violence against women and girls. It's why some of the legislative changes, perhaps they're not the changes that have made the headlines in the Ministry of Justice, but some of the legislative changes that we've made to ensure the availability of legal aid in cases where domestic abuse arises are so important. The equity disregard, for example. So simply the fact that someone who perhaps has had to flee a property, owns a property, that in and of itself doesn't take them outside eligibility for legal aid. It's really, really important. The other thing we're looking at, that's not a direct answer to your question, but it does go to who can access legal aid, is around the evidence tests that we're looking at and what someone has to substantiate in order to demonstrate to the legal aid agency that there is a risk of domestic abuse or there has been actual domestic abuse, which means that they have access to legal aid in the family court. I think our approach in relation to family legal aid will continue to be informed by the importance of targeting it at the most serious cases where domestic abuse and child abuse arises. I've got to be realistic with the committee at this juncture. When one looks at the level of spend in family legal aid, which now sits at £854 million, almost 200 million in private, the rest in public, it's a substantial sum. And what's interesting is that particularly on the public family legal aid side, we've seen over the last decade that the amount of that the government is spending on family legal aid has gone up by £260 million, there or thereabouts. That's not because there are more cases, and it's not because fees for family legal aid practitioners have gone up. There are other drivers of that, often to do with the length that cases are taking. And so why I say all that is that we need, as part of the family justice strategy, to look at outcomes, to look at how we improve the timeliness of cases, why the child-focused courts on the private side are so important, not just legal aid spend per se, which, as I said, has grown, but not necessarily achieving better outcomes or because there are more cases. So when that strategy is published, I expect that it will dovetail with the government's approach to reducing violence against women and girls, but it will also, again, need to be a holistic package. And as I said, really looking forward to the multi-committee event.
We look forward to the strategy. Thank you.
Thank you very much. Just before I bring Ashley Fox in, I have short questions on this from Sarah and Vicky. Sarah.
Ms Sackman, I have so many questions I could ask you, but I'll contain myself for the sake of the rest of the committee. In terms of, you referred to the expansion of legal aid into under the Hillsborough law, which I'm sure everyone would absolutely agree is a fantastic thing when it happens. But my concern is that when I have discussed this with practitioners, and I hosted an event about it, the practitioners said to me in no uncertain terms that the current civil legal aid rates represent just over about 12% of their normal hourly rate, and that it was inconceivable that they would do the work for the level of money that is currently on offer. Where do you think the practitioners will come from to provide this service? And do you have concerns that you are creating a public expectation that groups of bereaved families who have been through absolutely horrific circumstances will actually find re-traumatising when they discover that the services they've been led to believe they will be able to access simply don't exist?
Of course, we have a responsibility that where we make a commitment in statute to this, that that commitment is realised, and it's why the implementation of the commitment around Hillsborough law for non-means tested legal aid for bereaved families at inquest is one which is a real focus for the department. Part of that implementation involves consultation on the fee schemes to which you refer, and about getting that set at the appropriate level. It's about issuing new contracts for this area of work, which is an area into which legal aid providers, some will choose to move into, others may not. It's involves some of the digital changes that will be needed to underpin all that. And the funding of it will be important too, because the approach will be to require the public authority that is, if you like, involved in the inquest to cover the costs. And that's important because not only is that an approach we generally take as a downstream department, but it goes to what we hope will encourage proportionate behaviours by those public authorities. If they're going to have to cover the cost of the legal aid for a bereaved family, then, putting it very crudely, rather than coming all silked up with, an army of lawyers, that makes no sense. If you're going to have to, you have to look at the matter from a proportionate way and say, actually, does this really necessitate that, given this commitment to the principle of parity of arms, and that we are going to have to cover the cost of the representatives and advisors of the bereaved families. And I think that provides some level of proportionality to the whole approach. I don't doubt that this is a significant challenge, and it brings me back to what I was saying at the beginning. There's no point in having these rights on paper if we can't deliver on them in reality. And I certainly don't want to be in a position, I've got no interest whatsoever in being in a position where we're letting down those families twice over.
Yeah, thank you, Chair. So I just want to touch on the issue of violence against women and girls and family legal aid. We raised this with the those that came to give evidence previously. Families where somebody is claiming legal aid and is then using that access to legal aid to continue domestic abuse in a very subtle way against another party. So I'll give you an example of a father who was unemployed and therefore able to access legal aid. The mother of the children was working 2 jobs and had incurred tens of thousands of pounds in legal aid to just be able to keep accessing her own children. Her mother remortgaged her property in order to keep those children with their mum. And every time the mum challenged on the truth about the father's situation, it was, well, he's got legal aid, she hasn't. So there is a real worry about all very well increasing the family legal aid rates, but not if that's actually going to perpetuate domestic abuse in a really nasty, pernicious way. And I just would urge you to sort of really think about the impact on families of how legal aid is being abused.
Well, I mean, that case or that example that you give, I mean, it speaks to this, and there was this report out today that no doubt those on the committee will have taken notice of, the way in which we know that family court can become a site of re-traumatisation and, as you say, perpetuating the very abuse which may be at issue in the case. Of course, one has to look at both applications as indeed decisions, whether it's about child arrangements or financial remedy, on an individual basis, and you know, to a large extent, we entrust our independent agencies like the Legal Aid Agency, and as we do our family judges, to see the truth of the matter and see wrong from right in those situations. But obviously what you describe is something we've got to be alive to. I mean, you know, this is a real priority for this government. The fact that the introduction of domestic abuse protection notices and domestic abuse protection orders, which have been established by this government, are all covered by legal aid, I think is testament to that. There will always be those cases which are horrific examples, but it's where the family court has to change. And actually, the point that was made in today's report about transparency around family court and the publication of more judgments, the fact that better technology and transcription and what have you is enabling us to do that to the good. So it's not just about fee levels and money, it's also about outcomes and about improving the conditions and processes and judgment ultimately within our family courts.
Fox.
Thank you, Chair. Minister, in April 2025, you discovered that the Legal Aid Agency had been subject to a cyber attack. Now, my understanding is that information on providers and clients from 2007 through to May 2025 was hacked from between the 31st of December 24 to the 16th of May 25. Is that correct? Or do you have any more information you want to give the committee?
I think that is correct.
Okay. And I understand it that by November 2025, you had not informed individuals affected by the breach. Have you now done so?
So the position, and I will certainly ask Ms Harbottle to provide further detail on this. This was a criminal attack on legacy systems where a lot of personal data, subject quite rightly to GDPR and then ICO processes, was held in a very fragmented way. There is a lot of complexity around complying with those requirements, which of course we must do. And that is why it continues to take time, and the exercise is not yet complete in terms of getting an understanding and then informing those whose personal data may have been stolen by
more
the
than a
hackers.
year after the attack, you still haven't told the victims of the attack their data is being breached.
Shall I come in? So we immediately issued a notice. So on the 9th, I think it was the 19th of May, we issued a public notice with regard to the data breach, and we also informed the ICO in line with our responsibilities and duties. We did that because some of the data that we believed was exfiltrated was extremely old, and it dated back till 2007. So to just send out a notice to everybody without sort of being able to identify particular individuals would perhaps have created
Clear, when you say you put out a notice, you put out a notice on the government website.
We put out a notice, yes.
Because not everybody reads government websites, so actually most people wouldn't know that they'd been a victim.
No, so we put out a notice on the government website because we thought that was the most sensible and proportionate thing to do at the time. Just to reassure the committee, as far as the dark web is being monitored, and as far as we're aware, no information has been shared. And we do take this data loss incredibly seriously, and I am extremely sorry for any distress caused. I'd also like to just sort of highlight just how fragile and how fragmented this data is. It's incredibly difficult to piece together and identify individuals because of the state of our legacy systems. There is no one central data store that says, I, Jane Harbottle, had a legal case, this is what it's about, here's all the evidence. We don't run case management systems, we run sort of processing systems that gather some information. And that's across sort of 48 different IT systems, 100 different components. It's extremely fragmented. We've had a group of data analysts trying to piece this information together, trying to build it back up to a picture so we can say, what information do we think was exfiltrated for Jane Harbottle? That has proven extremely challenging. That work is more or less now drawing to a conclusion. There's another team at this moment in time quality assuring the data and also going through trying to deduplicate data, because it may be that in one particular system there is my name, on another particular system there could be my date of birth, and just trying to sort of deduplicate and sort of link it all to an individual is the work that's concluding at this moment in time. We've kept the ICO fully involved as to our investigations and the reasons for the delay, and we hope very much to have concluded the investigation and the analysis and have a sort of searchable index to identify individuals by the end of June. And I'm more than happy to write to the committee with an update once that's completed with what that is actually telling us. But it's just been extremely challenging given the way that our legacy systems hold the data to be able to extract it.
I mean, you referred to name and date of birth, but as I understand it, special categories of personal data have also been accessed. So people's health data, details of their sex life, sexual orientation, and then things like religious or philosophical beliefs and trade union membership. So it goes way beyond name and date of birth, doesn't it, this leak? And I find it, I find it astonishing. If this was a law firm that had leaked this information, I think the government would be all over this, demanding action. And here we are 12 months later, very sensitive personal data has been leaked. And you haven't even told people that this has happened.
Well, I mean, I think Ms. Harbottle has been really clear that we've informed the public via the notice. We're complying with the ICO. This wasn't, I do think it's important to remind ourselves that this wasn't a leak of our own making. It was the subject of a criminal cyber attack, and a serious one at that, and it's why the National Cybersecurity Centre has been involved in helping us get to grips with it. But look, The reason why this has been as serious as it has been, and you're absolutely right, that the nature of the information, if one could piece it together, it is incredibly sensitive, private information. But the reason that this happened is A, because of criminals, but B, because of the vulnerabilities of the system that we inherited, that no one bothered to invest in and put security around. That's what we've invested in. £200 million now over this spending review.
I know it was a result of a criminal attack, and my concern is that 12 months later, whatever the cause of the leak, the victims don't know that they're victims of this attack. And admittedly, some of this information is very old, 2007, but quite a lot of it won't be. It will be really quite recent. And there seems no sense of urgency.
Well, I reject that. There has been a huge sense of urgency in two regards. One, in keeping the show on the road at the Legal Aid Agency, even when we had to take our systems offline, and ensuring that no one who needed legal aid was denied it during that period. That took a huge amount of work and urgency, and I saw real effort from the part of the Legal Aid Agency to restore the systems. And secondly, I reject the suggestion that there isn't a lack of urgency, but we don't want to get it wrong in terms of identifying who, if they have been a victim, is a victim. We don't want to be telling people they're victims when they haven't been. You know, this thing having gone as badly wrong as it did as a result of criminality, we have a responsibility as a public body to get it right. But please don't let the committee be in any doubt that there is any lack of urgency or a sense of complacency at the Legal Aid Agency. If there is, I've not seen it.
I move on, because no doubt providers and clients have suffered losses as a result of this breach. Are you aware for any claims for compensation from providers and victims?
I'm not aware of claims from victims. I'm aware that there have been calls for compensation. Individual cases where there were specific reasons for additional costs, claims can be made to under the Legal Aid Agency's costs guidance, but there is no compensation scheme. And that's for a couple of reasons. One, because, as I said, putting it colloquially, and I want to acknowledge the provider base here, we did succeed in keeping the show on the road through a series of contingency measures, an average payment scheme. Providers were able to take on work and to keep their cash flow going during the period, and worked well under significant pressure with the Legal Aid Agency to keep things going. And I want to thank them for that. I think, though, secondly, our approach should be to looking to the future. We're making significant investment in restoring and transforming the system. My question was about compensation and the possible liability of the taxpayer for those liabilities. Can you give us an estimate of how much you think the taxpayer might be on the hook for? Or are you not intending to pay any compensation? Well,
I was going to say, is this for people whose data may have been
providers
breached?
who've lost a great deal of time and effort in dealing with this issue, and secondly for potential victims?
Okay. In terms of the provider base, as the Minister has set out and wrote to this committee, there are no plans for a compensation scheme. You know, I would like to add my thanks as well to Minister Sackman, because I think the provider base have been amazing. They've worked really collaboratively and cooperatively with us. And of course, an attack of this magnitude and this scale, of course, has had an impact on them in terms of the way they are operating their business, not least reading
So no compensation for providers. What about victims?
For victims, we have some live litigation at this time. So we have a couple of live litigation cases and also a few pre-action letters. So it's really not appropriate for me to discuss at this time. So I can't give you an answer to that at this moment.
The Permanent Secretary of the MOJ told the Public Accounts Committee that the MOJ wanted to spend more on IT systems, but this was subject to allocations. So how much funding has now been allocated to the legal aid system transformation, and what assurance can you give us that this is sufficient?
So in terms of the investment for 2026, we've put an investment in of £61 million, which represents a significant increase, over 100% increase on the committed amount in 23-24. Over the spending review period, there has been an allocation of £200 million in additional funding. Some of that will have already been directed at stabilising the system and standing up the security that's needed. The hope is that an investment of that magnitude over the spending review will allow us to move off the legacy systems and onto secure, transformed systems, which will improve the user experience for providers.
So you think that the 200 million will be sufficient to replace those inadequate systems that you've described and which you said are totally unfit for purpose?
I do. I can't say with absolute certainty that work will be complete within the spending review period, but I do think that represents a significant investment capable of achieving that goal, yes.
And that takes us to March 29?
That's right.
Fine. Thank you, Chair.
Thank you very much. I think we move on to Tessamont.
Thank you. So you referred to the new legal support grant, which runs from this October to March 2029. Just wondered what lessons had been learned from previous grants that are going on at the moment, because we've certainly heard evidence that legal advice organisations are completely overwhelmed by the demand for their services and they're under-resourced. And when we look at the Welsh Government example, they've got a nationwide advice strategy which seems to help and support the provision of social welfare advice services. Why isn't the Welsh example reflected here? And what are you planning or what are you doing to support the sustainability of the advice sector? And as I said, what have you learned from previous and ongoing grants? There are only 3 questions, sorry.
I'm absolutely passionate about legal support. I started my career at the Free Legal Advice Centre in Toynbee Hall, so I'm in no doubt about the value that legal support provides in terms of helping people access justice, understand their rights, and be able to advocate either for themselves or find a lawyer. And what pleases me about the approach we're taking is not just the commitment to multi-year funding, the 20 million over the next 3 years to enable those who receive legal support grant to plan ahead to do the brilliant work that they do, but the fact that the Ministry of Justice, through the Legal Support Strategy Group, is taking a strategic approach. And I've attended a couple of their meetings, and round the table, a bit like this one, we have people from the law centres, from citizens' advice, practitioners, different representative bodies, bringing together that work, and they're doing a lot of research and evaluation, so that what I think a lot of us around this table, and I think I understand intuitively, which is the value of legal support, has an evidence base, because that will secure, I think, its future and make sure that grant is targeted in the best places to get the best impact for the citizen. The other thing I would say to your question is that it's clear that there is a need for far more joined-up thinking across government. And I have sought to engage with other government departments, with the Ministry of Housing, Communities and Local Government, with Department of Health and Social Care, thinking about 2 things in particular. One, advice sector budgets, because speaking to the Derbyshire Law Centre yesterday, a whole chunk of their budget comes from MOJ, but a chunk of their budget comes from the local authority. So thinking about budgets in a joined up way. And the other thing is about where do we deliver legal support? Can we think much more creatively about co-location of services? The government is rolling out a new generation of Best Start hubs, of neighbourhood health centres. What would it mean to have legal support provided in those spaces where many of those who are affected by legal problems might want to access legal advice? So that cross-government work and that strategic work that's happening within the group, I think, are going to prove over the long term incredibly valuable.
Thank you. So you give me your view of the Welsh system, because I'd be interested to know what you think of that nationwide approach.
So I think in general terms, I think I am attracted to a national strategy, and I am, in my, I suppose, wildest dreams, attracted to the idea of a national legal service. We have this mixture of provision, don't we, that we've been discussing today, of legal aid, of private providers, of charitable providers, state funding, and having a coherent joint system of the sort that the LAPG has and others have advocated for is one that I certainly find attractive. I think that the work of the Legal Support Strategy Group and the research and evaluation that the group is commissioning and reviewing could, I hope in time, provide a framework for how we develop that. As the Minister with responsibility for legal aid and legal support, that is something that certainly animates me, a national legal service. Wouldn't that be a great thing?
Yes, because I think if there's some sort of universality, it helps people in areas like mine, which are incredibly rural. And we already know, don't we, that there's 1.6 million people who are not online at all. And I think it's 23% of people have very low digital capability. And, I mean, quite a lot of people, if they need to go to court in my area, they have to leave the day before if they're reliant on public transport. So, justice is not accessible in rural England. And, you don't have to be very far down. If you don't have a car, you're completely banjaxed. And so I just think it's that whole thing where there are so many people who don't have access to justice in all sorts of, not just geographically, but as you were talking about digital stuff. I just wondered how you might, the attractions of a national service and a nationwide service mean that people would know where they could find help. Whereas at the moment, if somebody in my area thinks they have to go to Bristol to get some help, that's where the nearest legal centres are deemed to be. It's quite a long way, and the buses don't join up, and there is no, I've got one station in my constituency which I drive 20 miles to. It's not accessible at all. I just wonder what your vision might be.
Yeah, no, I'll bring in Ms. Ziaulla in a moment. I do think, and I take the point around digital exclusion, which is a separate issue, but I do think that in this regard, a common universal badging of services might have merit. It's not within our current plans, but I think I've said to you that it's an aspiration. And I think that this is where the harnessing of technology, I think, and remote access can be totally game-changing. When you look at the funding that Ministry of Justice provides to the Advice Now website, the way that we're developing digital tools, if you go now on the gov.uk website around child arrangements and the pathways and using digital tools to allow people to gain support online as well as signposting them to a legal support provider. These are potentially game-changing if we harness it in the right way, and could be game-changing for your constituents, but also my constituents in an urban area. I'm an MP in the most populous borough in London. We don't have a law centre. We've set up a pop-up one, for which there is huge demand. But there are challenges in different parts of the country. But I think if people know where they can be signposted to help, where they can access help that works around their lives, whether that's a reality of digital exclusion or a very busy working life or caring responsibilities, which mean you don't want to have to travel long distances to have a face-to-face, but actually a video conference with someone really well qualified would do just as well. I think we've technology here, I think, has rich potential for realising some of the promise of access to justice, which I know that everyone in this room is committed to. But did you want to add to that?
Just simply to add to that, I think the signposting is critical, and there is this wider ecosystem of agencies, advice centres, bodies that exist that are doing fantastic work and are really keen to signpost if they themselves don't cover a particular area, either geographically or sort of from a subject perspective. I know from my conversations with them that they want to be able to tell people where to go and have that kind of online and in-person offering as well. In terms of the existing grant that's been extended by 6 months, an interim evaluation absolutely spoke to the value of that information and that support. So a couple of figures, that grant has supported 110,000 people with 163,000 legal issues over that period of time, and those issues were primarily related to welfare rights and housing. And advisors reported that 73% of clients displayed a better understanding, because it's that navigating what the issues are in the first place and ensuring that they don't start to cluster and become overwhelming. As the Minister has said, our focus for the future and our intention in having a multi-year funding approach is that we have the certainty, we can provide that certainty to organisations who are funded by the future grant in terms of their operation. And we are working with the Legal Support Delivery Group and we are building in an outcomes framework into that process and an evaluation, a live evaluation, so we know how to target the services and we know what has the sort of maximum impact, and that can inform future funding and future initiatives. So it feels like, albeit this is where we're interacting with people at their most vulnerable, and so perhaps feels a bit odd to say this, but it feels like a very exciting moment for the funding and the strategy of this sector going forward, because we are building on all of the good work that these fantastic organisations do, who are working very, very collaboratively with us, but with the intention of having a very clear evidence base that informs that future approach. And as the Minister has said, that also goes to co-location of services, so that individuals don't actually have to go to a law centre or a legal advisor. They might be able to access that support in a GP surgery, for example. So it's looking at, what is more accessible and perhaps less intimidating as well.
Okay, yes, I mean, I'm just raising the flag for those people who have to somehow go 7 miles to the surgery, their kids go 8 miles to school, they go 20 miles to a station, there are no buses, the library's shut, just on and on and on it goes, and they have no mobile signal, and even in, the city of Wells, the whole of East Wells has no mobile signal. So how do you, can you afford a computer? Do you have access to the internet? No, you don't. You need to bring services to people, please, all the time. But I'll stop there, otherwise I could wang on for ages.
Thank you. Tony Bond.
Chair.
Thank you, Chair. Just staying with this theme, I actually wanted to ask Miss Ziaulla about chatbots, because more and more people are using them, because obviously there's less, well, as we've been speaking, there are barriers to accessing legal advice and representation. And so I just wanted to know what you're doing or what the government's doing to address the risks inherent in that, and how long is it until we get to a situation where, and I think things are being done, but I just couldn't find when I was looking before this session, what is being done to actually help people identify what law could potentially apply in any given situation, because even if you're making clear that it's not a sort of total picture of the law that could apply in any particular situation, at least it's a starting point perhaps. But just wondered what you said about those things.
Yeah, absolutely, and I think this is an area where, I mean, fit for all of us as individual citizens as well as users of service. Technology is moving on so swiftly, and for government it is really key that we keep pace with that, but we also look at the opportunities that offers, and we know that the advice services that we work with, as well as what we do internally, are very keen to capitalise on that. But as you sort of say, there are challenges and there are risks, and we do need to be sort of mindful of the information that can be generated, and that people aren't overly reliant on information that we aren't clear is robust. There is quite a lot we are doing within the Ministry of Justice, and we're sort of holding ourselves out as a leader within government in terms of our AI approach, and we're also looking at the use of AI in our kind of transformation approach, both in transformation of the Ministry of Justice approach to services overall, but also within legal aid. So there is a lot that we are doing here. I might need to just refer to my notes quickly just to pull out a couple of specific examples, but it is something that we're really live to, and absolutely do see the benefits and want to ensure that we are utilising that technology in the way that we are supporting.
I mean, is the government moving towards a system where you can sort of put all the law in one large language model to allow somebody to put in their factual scenario, and at least it pull up a series of various laws? Because, I mean, there is a finite amount of law, there's a lot of it, but it's only really accessible to people who can pay for Westlaw or whatever, to actually find out something that will tell you the statute, the secondary legislation, the cases that have interpreted that. And really there is no reason in principle why a citizen should not be able to access that, and why anybody should be prevented from accessing that simply because of money. And I just wondered where we were with that.
No, I was just going to, so the Legal Aid Agency actually within the Ministry of Justice now sits within the Service Transformation Group, and as part of that group there is an AI unit sort of leading on AI thinking across government, and done some really creative things like Justice Transcribed to help free up probation resource, etc., and work in the family courts as well. So this is a live conversation that we've just been having, because if people are going to do it anyway, and they're going to look from their own phone, and they're going to get potentially incorrect information back. I think there is a broader conversation to be had. I mean, maybe speaking out of turn because we haven't discussed this yet, sort of ministerially, but there is a conversation to be had around, well, what is the role then that MOJ or somebody else plays in terms of ensuring that there is a repository of almost quality assured information? And of course you can partner with tech companies, etc., who will model these and do this for you. So that is a live conversation at this moment in time. The other thing we're thinking about as part of our transformation program, so we've got sort of 4 big aims for our legal aid transformation program, and granted at the moment this is for people who can get legal aid, but the first is to reduce provider administrative burden. As Minister Sackman said before, the overheads of doing legal aid, the friction of doing business is far too great. We've got to take that out. Secondly, simpler, faster, fairer access for clients. And that's about, if somebody is entering in the legal aid system, can we do something with tech to indicate if they're going to be likely to be eligible for legal aid? If not, could we triage them to, other sources of advice and help, or advice services, alliance services? How could we use that front end interface more creatively? Could we do the means test in the background for the client and refer it onto a provider, and then, hey, we'd know exactly what cases providers were taking and what cases they weren't taking, wouldn't we? Because we'd have it all in the system. The obvious one following the cyber attack is anything we build, secure, assurance built in, etc. And then I think the third one is to enable the LAA to process and make decisions at a far faster rate and pace than we do now, so that people have certainty of legal aid funding sooner rather than later, and that bills can be paid hopefully on a more
Can I just ask though,
way.
how far along the road are you to actually using the technology to practical effect? Because all the things you've said are really exciting, they strike me as all being really urgent and should be really being progressing. I know often you use the word at pace, but that can really mean anything. And this is an area where it seems to me you've got huge potential to cut costs in the long term. And that if there was a little bit more investment or urgency, that it could result in a lot of savings further down the line, particularly as the Crown has copyright over every single piece of law that's passed. And so I remember working with legal aid providers who couldn't even afford Westlaw, and that seems mad, given that you own the copyright on all the law.
Okay. Yeah, I mean, I can't give you a time frame in terms of the sort of wider piece of work you're talking about, but just a real life practical example. So we're currently piloting a piece of AI with my operational caseworkers at this moment in time. You know what LASPO regulations and legislation is like. It's very complicated. It really helps them very quickly get to, is this matter in scope? What's the guidance around it? Am I applying the correct criteria? Takes them to the correct place. That's the sort of thing. I mean, I think we're at 95% accuracy already, and that's in a matter of weeks. So that's the sort of thing that we really want to build into our transform systems, because why isn't that available to providers? That would really help them cut down on their administration. So this is why, reducing provider administration costs is absolutely, first and foremost in our transformation journey, as well as easier access and better access for clients.
Just lastly, so I'm clear, who is the ministerial lead on that? Is it Minister Sackman, or because I didn't know whether one of the law officers was also leading on it?
Well, I was going to say that Lord Timpson leads on a lot of this, but I would say it is pretty cross-cutting amongst the ministerial team at MOJ. And I was speaking to the director with responsibility for transformation. I mean, at the risk of blowing our own trumpet, which we don't often get to do in MOJ, the Ministry of Justice really is first in class at the moment in terms of AI adoption and experimentation within government. And there are some really exciting things. If you look at the growth of the team of Justice AI within the department, in terms of the number of people and the calibre of the people we're pulling in, it's really exciting. And all of the things that Jane has referred to, but also to your point about, if people are going to do this anyway, how do we make sure they're using correct information, that we're not hallucinating and making up authorities or making up law, that it's referring back to gov.uk website? As I said, I mentioned the family law example. That is live already to help people understand, well, what is my position? And it takes you through a simple but verifiable user journey. What you've described and what Jane's described is the future, and I don't think it's that far away. It is a real priority within the department for all the reasons that you say, not just because of saving time and money, but because of this point about empowerment that we were talking about earlier. Yes, of course, we have an aspiration that people should be able to access a lawyer and representation, and we want that to be available to as many people as possible. But, knowledge is power. And the fact that this information is accessible to people, provided it's correct, and provided we are building tools that people can have trust in, then I think that could be hugely empowering for the citizen. And it is happening.
No disrespect to our witnesses, but we're likely to have several votes soon, and I'm going to try and get through as much business as possible. We've got a couple of questions from Vicky Slade.
Yeah, I'm going to be as brief as I can on a similar issue. AI-driven legal tools and advice is not currently within the scope of regulation of the Legal Services Act. Given that so much is happening, is this sustainable? And then more broadly, in terms of the Legal Services Act reform, in oral evidence that we had a little while back, there was talk about some of the reserved activities need to potentially be changed. So what is happening in terms of, given the changes you're making in terms of your use of AI and the public's use of AI, how the regulation is also keeping pace with that? Because when it goes wrong, how are we going to take AI to court?
Well, look, I mean, there is clearly, as we have London Tech Week and so many of the stories, there's a huge amount going on in public discourse around the ethics and the approach to AI, and that's no different in public services as it is on social media and in other spheres. So we can't divorce ourselves from that huge responsibility. When I meet with the regulators, as I do on a regular basis, I'm always asking them, what is your sense of the areas of risk? Where are the areas of vulnerability in our system? Because that's your job, not just to see the risks for the here and now, but to anticipate that. And one of the areas where we've spoken about, both in terms of consumer protection, but also with a view to innovation, is around the use of sandboxing. And so using our regulatory system and our regulators to set up regulatory sandboxes for the experimentation with AI, so that when we begin to utilise it, we can do it in a safe way. So that's important, about identifying it as a risk area and making sure that it is an area of priority for those regulators, but also enabling the innovation, which is going to be so important to making all of these tools available to people. And it's, I suppose, one of the several areas of challenge for our Legal Services Act and for the regime, and no doubt it will come out as an area of focus when we get the forthcoming review into the performance of the LSB, for example.
So just in a nutshell, you're open to reviewing whether such things might come into scope of regulation in the future?
I'm of course I've got to be open to that. That is not the same as saying we are doing a wholesale review of the legislative framework, but of course we can and we must be.
Thank you.
Thank you very much.
Thank you. So your consultation on interest on lawyers' client account scheme to raise additional money for the justice system has just closed relatively recently. But we heard in evidence to this committee from Professor Linda Mulcahy, she was fairly critical of some of the specifics of your proposal, in particular that it was not going to be administered independently. So I just wondered whether you feel you are likely to proceed with the scheme or something similar, and whether you will commit to independent administration of any additional funds that go to access for justice purposes.
Well, the government will provide a full response to the consultation. We received many responses, and it's important that we do that in a proper way and in proper time. I'm not going to commit to any precise or specific form of any scheme. I'm not going to preempt that now in this committee. But I am glad that you have drawn the link between the discussion today in relation to access to justice and the sort of funding pressures to which a number of you have alluded, and the rationale behind the interest on lawyers' client account scheme. This is a model that exists in other jurisdictions, in America, in Canada, and parts of Australia. And the reason we are doing it, and we think it's a good model, is because, not necessarily doing it, but why we are consulting on the idea, is precisely with that in mind. I was explicit about that in the forward to the consultation. The linkage to access to justice is why we are entertaining this idea, because, I suppose, for two reasons. One, the need that we've all spoken about, the need for access to justice, and secondly, the recognition that those firms in this country that deliver brilliant services to their clients and support lots of employment and businesses do so in no small part on the foundations of the British justice system. And that depends on the integrity and the viability of that system. And, you know, they can't go about their work without a rule of law which vindicates the promise of access to justice. And that's the thinking behind this. And that's why we're exploring this idea.
Can I ask you what you feel would be the disadvantages of having independent oversight of this?
I think you know, one can get into the details of a particular model. We've got to decide first of all whether the principle of it is right. We've got to get the design right. There may be advantages to having an independent operator. There may be advantages whether to do with administrative burden and cost, and then where money is redirected to access to justice purposes of keeping it within the Ministry of Justice. I can see pros and cons, but I'm not going to speculate on what would be a preferable model. Thank you.
Thank you. Brenda.
Thanks. Can I ask you couple of questions on funding options? When the Access to Justice Foundation gave a written response to our inquiry, they suggested that there should be a mixed funding model to raise additional funds for access to justice. I know that the government has considered interest on lawyers' clients' accounts, but have you considered any other options in terms of having funding models?
I mean, there are a whole host of funding models which I think are often in the minds of policy officials within the Ministry of Justice. The one that we've consulted on is the ILCA model, the accruing of interest on client money, which seems to be treated in different ways by different firms, sometimes remitted back to the client, sometimes retained, but rarely actually critical to the profitability of those firms, seems to us to be a model which has some merit, not least because it's a model that exists in other countries. And where one can see the linkage for that shared responsibility for our justice system between more profitable firms and the wider access to justice ecosystem. So, to your question, of course there are other models that one might consider and which are kept under consideration within the Ministry of Justice, but this is the one that we've consulted on and which we're looking at most closely at the moment, and on which we'll provide a full response in due course.
Thank you. I have a very quick question, if I
Sure,
may.
I'll try and give a quick answer.
It's relevant to access to justice. So I had a meeting with the Consumer Legal Association last week, who have raised issues about third-party disclosure, in particular disclosure of information and police records from police forces. There have been instances apparently where there have been delays since April 2025 for the police to disclose records, and in one case a 6-month delay was considered to be acceptable, and this is obviously having a knock-on effect on lawyers being able to investigate and move on with their cases. Are you aware of any such issues? And it may be something that I need to...
That doesn't sound like a short question or a simple one.
Right, sorry.
But a good
it may
one.
be something
no
that I
less
need
good for that.
to take up with you later.
With your permission, the Chair's permission, I think it'd be better. I can give you a more useful answer if I come back and write to you and the committee with a response to that. That does sound like an alarmingly long time for that kind of disclosure, but I'd want to look into it.
That would be helpful. There's no obvious reason for why it should be happening. But
I agree.
And it's variable between police forces, I think, but it's a problem everywhere. Yeah. Sarah.
Minister, the last thing I wish to ask you about is that we currently have a backlog in the employment tribunals that's now approaching 5 years. The backlog has gone up by 26,000 in the last year alone. It's a really steep increase. I was wondering if you have had any thoughts about how this might be tackled.
Well, it is a serious issue. Of course, much of our public debate has focused on backlogs in our criminal courts and particularly in the Crown. But I am mindful that many people look to enforce their rights in our tribunals, not least the employment tribunal, and that level of delay and backlog is not acceptable. And of course, I'm mindful too of the new generation of employment rights that I'm proud that this government has created. But the tribunal needs to be in readiness, again, so that those are not just rights that are written on paper, but rights that people know they can enforce in a tribunal if they need to. It's not just about getting to the tribunal, it's knowing that when you bargain or seek to enforce your rights within the employment context, you know that if you needed to go to tribunal, you could, and it wouldn't take an awfully long time. That's really important. So this is about investing in capacity, ensuring there are enough tribunal judges and lay members. It's about diverting inappropriate cases, cases hitting the tribunal, whether that's through the role that will be played by the Fair Work Agency, but also by mediation services, ACAS, and ensuring that that is bolstered. We don't want to create barriers to accessing the employment tribunal, and it's why we haven't looked to introduce fees for accessing the tribunal. But timeliness is obviously a really important component of justice. And so the efforts around capacity, but also alternative dispute resolution, are really, really important. And it's something that is a real area of focus for me and the policy team.
I just pick up on that, please, because I think I'm right in saying that the queue to get into the employment tribunal is about 80,000 cases, maybe slightly over. And I have a particular interest, and I've declared it already, in whistleblowing. And the only route for people who have suffered detriment as whistleblowers is to go through the employment tribunal. And it can take years for people to go through. And they are people who have usually lost their job as a result of being honest about something that's gone wrong in the organisation for which they work. Only workers can actually whistleblow, technically. And we have to do something about this, because you're talking about trying, perhaps, I'll use the word filter, trying to filter people maybe to some other resolution. The only thing, in my view, is to have an office for the whistleblower who could deal with very specifically those cases. I know that the government has considered this, the Cabinet Office has it in front of it. There are lots of suggestions, and I would ask very, very serious consideration is taking that group of people out of the employment tribunal, particularly if you're even half thinking of fees. If you are, that's going to be completely inappropriate for people who don't have any help and have very often lost their whole income. I think the employment tribunal is a total nightmare.
Duly noted.
Thank you.
I'm going to try and get one more topic in, just a small, in the last 5 minutes. It's a small topic. I think we appreciate what the government's done so far in relation to increasing some legal aid rates and taking steps where the problem is worse. We're nowhere near replacing what was lost over LASPO. So there's an increasing focus on third-party litigation funding. So the first point is you did undertake to reverse the PACAR judgment.
We did.
And we were expecting to see that in the King's Speech. Could you tell us what is happening with that, and whether, when you do that, so I assume you're still going to do that, it will be retrospective as the Civil Justice Council recommends?
So you're right, we've announced that our intention to legislate to reverse the effects of the PACAR decision, but you're also right, of course, that it's not in this King's Speech, and that's because of the many competing priorities that the government has, but that's not to dilute or to reverse that stated intention. And it was important to state it because it sends a signal of the government's intent, and not least to those who are looking to litigate elsewhere or what have you. More generally, we are taking time to consider the other recommendations that the Civil Justice Council made in regard to litigation funding, and perhaps one advantage or silver lining of the delay is that it will give us further time to consider more holistic or wholesale changes that might be desirable, and we can bring forward our fuller response in due course to that. You mean in terms of litigation funding from other sources other than
Yeah, because that review was pretty wide ranging, and so I think there's a moment to reflect on those broader issues.
Is this part of your wish for a national legal service, that you wish to see greater opportunities to cover legal costs?
Well,
I'm give an example. There was a significant event here yesterday for legal expense insurance, and the idea that which is familiar through household and motor insurance, but could be more of a form of social insurance for legal costs on a wider basis. Is the department thinking about, is the ministry thinking about those sort of changes that could give more access to justice?
So, whilst there isn't any sort of formal plan in train, and one has to be sort of careful, I don't want this to be sort of written up as Courts Minister announces, fill in the gap. But I think, as I hope I sort of set out my stall in opening, we have a huge legacy in this country and a huge constitutional principle that's been recognised the courts around access to justice, and the inheritance of that Attlee government is one that I take really seriously. My immediate inheritance coming into this role was dire, and everything that I've sought to do in my year and a half in this role has been to stabilise and rescue the system, and I don't minimise for 1 second the scale of the challenge. But once we begin to see the green shoots of that investment, which I am confident that we will, then I think that we have to be bold, and we have to open our eyes to the possibility to reimagine what access to justice in this country could look like. When I read the LAPG's paper on a national legal service, they talked about requiring a coherent understanding of what the purpose of legal aid, legal support and litigation funding is. They talked about the need for innovation and technology. They talked about the aspiration of that universal idea or a single national badging, which was referred to by Miss Munt. And they also said that it might take a really energetic legal aid minister to animate this subject and this debate. And what I see within the Ministry of Justice in this role is that we are entertaining these ideas, we are open to them. ILCA itself is an example of that. How might we consult on different funding streams to really enliven access to justice? We've got to keep our eyes open to these ideas, because it's only that way that we're going to revive and be ambitious in the same way that they were post-war when they set up the legal aid scheme.
Good place to finish. We're exactly on time. Yeah. And we've got something to do now, which is to go and vote. So thank you very much, Minister, and thank you, Harbottle and Ziaulla. And with that, I'll end the session. Order